All right, I think what we'll do is jump right into the commentaries on the laws of England by Sir William Blackstone, who was commissioned to write the laws up until his time, which is he wrote these between 1765 and 1769. They are the heartbeat of the law for all English law. This entire commentary, it sets the foundation, not only the history, but how we have arrived in ascertaining those rights of persons and those rights of things. And we're going to read from Book 1, Chapter 1 of the Absolute Rights of Individuals. And this will sort of kind of move into what our topic is of being the Act of Settlements 1700 and 1701. And let me start off with mid-paragraph here. The Habeas Corpus Act passed under Charles II. To, to these succeeded the Bill of Rights, or Declaration delivered by the Lords and Commons to the Prince and Princess of Orange 13th of February 1688, and afterwards enacted in Parliament when they became King and Queen, which declaration concludes in these remarkable words: and they do claim, demand, and insist upon all and singular the premises as their undoubted rights and liberties. And the Act of Parliament itself recognizes all and singular the rights and liberties asserted and claimed in the said declaration to be true, ancient, and indubitable rights of the people of this kingdom. Lastly, these liberties were again asserted at the commencement of the present century in the Act of Settlement, where, by the Crown is limited to his present Majesty's illustrious house, and some new provisions were added at the same fortunate area for better securing our religion, laws, and liberties, which the statute declares to be the birthright of the people of England according to the ancient doctrine in the common law. And that is what we want to focus the attention on, is the birthright of the people is the English common law. Okay? Now, does that mean if you're using if you are using law that might be pertinent to, let's say, a claim made by Scotland or something initiated by New Zealand, or let's also include the U.S. Does it mean that you, because you're not a citizen in any of those countries, let's say, that you cannot use their laws? No. We have to look at the birthright of the people is the English law. That means the entirety of the English law, but predominantly the common law, to which those other interests being, like I've just mentioned, some of them New Zealand and US and so forth, those are territory laws that are pertinent to that territory, which is an equitable interest that is derived from the common law interest. So it doesn't matter where you are in the world, as long as you can use the English common law as your foundational law in which to then extract proportionate areas of other interest, being in equity, to maybe um, bolster up your rights that you want to express within your common law rights. But again, it's important we don't want to commingle. So if you're starting to speak to case law subject to the U.S. to solidify your rights, you may, at that point, if you're not understanding what you're doing in that instance, you may commingle um, the equity law into the common, and thereby create a breach. And as such, the foundational principles of the territorial rules is to then push you back into their jurisdiction. You're just going to have to remember when you have to establish when you know that you're talking within the common law, and then using certain proponents of other law to discuss the matter, not to commingle, but be able to maybe establish a contrast. So It is why it is important to go through the course and understand what law is, so that you know when you're using an instrument within another feature, let's say in equity, only as a in contradistinction or as a adversary measurement or something to bolster your debate, but know to the fact that you are not automatically not knowing that you may be commingling it and therefore be brought into the territorial rules of the U.S. or Canada or New Zealand and such. So the point here, that maybe I'm rambling on and I'm just sort of going sort of impromptu, but still wanting to speak to the Act of Settlements, is that the foundational principle of the Act of Settlements, 1700, is to acknowledge that the birthright of the people of England is the English common law, or the English law, which is everything that is subject to the English law, which we know derived into the courts of chancery, which are those interests that established through an equitable interest. Now, what we can do is maybe expand upon what it is that we first have to establish. I always speak to dominion. Dominion is separated from common law, and common law is separated from equity. Make sure that each one is secured within their own right. That's why each thing is separated intentionally, but maybe to look at what it is that it understands already as being your inherent right, and those are of absolute right. So we can go into uh, further reading of Blackstone's here, whereby it says the rights of persons considered in their natural capacities are also of two sorts, absolute and relative. Absolute, which are such as appertain and belong to particular men, merely as individuals or single persons. Relative, which are indigent to them as members of society, and standing in various relations to each other. The first, that is, absolute rights, will be the subject of the present chapter. Very important point there. Relative are those rights that belong when you're interacting as an individual with society. Absolute rights have nothing to do with society. Okay? There again, highlighting the aspect of dominion. It goes on. By the absolute rights of individuals, we mean those which are so in their primary and strictest sense, such as would belong to their persons merely in the state of nature, and which every man is entitled to enjoy whether out of society or in it, but with regard to the absolute duties which man is bound to perform, considered as a mere individual, it is not to be expected that any human municipal laws should at all explain or enforce them. So there you go. They're not in your constitutions, right? For the end and intent of such laws being only to regulate the behavior of mankind, as they are members of society and stand in various relations to each other. They have consequently no business or concern with any but social or relative duties. Let a man therefore be ever so banded in his principles or vicious in his practice, provided he keeps his wickedness to himself and does not offend against the rules of public decency, he is out of the reach of human laws. Have we not been discussing that? You're not under English law. You're not under any laws whatsoever. Okay? You're only noticed in laws, and we'll go into as it further will detail, when you affect something within the public realm that offends. Okay? But not to the offense that we've got all these arbitrary rules, crossing the streets or not coming to full complete stop and not wearing your seatbelt and all of these myriad of laws. They have nothing to do with you, okay? Long as you're in your own power first, you act in that own power, but it's decency. You mean you don't walk through the street naked. Um, you don't flaunt yourself. Well, actually, it'll, read, it'll bring to one point here so you can have a better understanding what it means when you are start now under the scrutiny of law. Okay, but if he makes his vices public through, though they be such as seem principally to affect himself, as drunkenness or the like, they then become, by the bad example they set, a pernicious effects to society, and therefore it is then the business of human laws to correct them. Here, the circumstance of publication is what alters the nature of the case. Public sobriety is a relative duty, and therefore enjoined by our laws. Private sobriety is an absolute duty, which, whether it be performed or not, human tribunals can never know, and therefore they can never enforce it by any civil sanction. But with respect to rights, the case is different. Human laws define and enforce as well as these rights which belong to a man considered as an individual, as those which belong to him considered as relative to others. So do no harm um, in society. And I know that everybody has that foundational principle. That's what creates the common law rights to us to act. But it's not even common law. It's just our absolute rights to, you know, be responsible. That's it. There's nothing more than that. And if you're not being responsible, okay, well, that's when the law interacts, and because people then are concerned with your actions within society. Okay, so active settlements predominantly is sort of the used as a annex to the Bill of Rights. Notice of your right, your absolute rights to affect any part of the English law, because that is your birthright. No one can take that away from you. All right? Now, let me just see what the time is here. Okay, why don't we stop this and then we'll go into the Act of Settlement 1701. First, I got to find the right button.